10 steps in the litigation process. Today, I'm going through these 10 steps that you need to understand about your lawsuit so that you can be better prepared for what's going to happen. I'm Natalie Gerry, the principal lawyer and founder of Gerry Law. I help injured people get the compensation they deserve for their injuries. Let's get into this today. The litigation process can seem daunting, but understanding the steps can help you feel more prepared. So I'm going to go through these 10 stages of litigation so that you can better understand the process. So step 1 is starting the case. And this is where jurisdiction is decided and the statement of claim will be drafted. So the first step is deciding where to file the lawsuit. Claims of $35,000 or less go to small claims court, and claims that are more than $35,000 and less than $200,000 go in the Ontario Superior Court, but the simplified rules apply. So it's a bit of a simpler process that's meant to be faster for these smaller claims. Over $200,000, the claims go to the Superior Court and they're filed in the regular procedure. So once jurisdiction is determined, then the plaintiff, so that's the person starting the lawsuit, files the statement of claim, and this is how the lawsuit is actually started with the court. The statement of claim outlines the facts, the legal basis, and the compensation being sought. This document has to be filed within the applicable limitation period, and this is normally 2 years from the date that the harm was discovered. Then within 6 months after having the claim issued, it has to be served on the defendant. There are some exceptions that apply to this, so it is important to get specific legal advice on your situation. Step 2 is the statement of defense and potentially the counterclaim or a third-party claim. Let's just keep it simple though. So the statement of defense, this is where the defendant, so the person being sued, has to respond by filing a statement of defense within the specified time frame, and then they explain why they believe they should not be held liable. So they raise any defenses that they have to the claim. If the defendant has a claim against the plaintiff, then they will file a counterclaim within the same document. This is pretty rare in a personal injury situation. A counterclaim would usually be something where they would be claiming back for damages against the other party. Usually more arises in a commercial dispute. So failing to respond to the statement of claim can lead to default judgment. So if the defendant just fully ignores the claim, then the plaintiff has steps that they can take to get a judgment without the defendant defending. This is a somewhat rare situation, so more legal advice would be needed on that situation. Let's go to step 3. This is the reply and defense to counterclaim, if there is a counterclaim, and if you need to do a reply. So if the plaintiff receives a counterclaim, they do have to file a defense to it. Otherwise, they can be noted in default in terms of the counterclaim. The plaintiff can also file a reply to address any new issues raised in the defendant's statement of defense, and to especially address any issue with the limitation period if the defendant raises an issue with the limitation. Step 4 is the discovery plan. So this is where you move into getting the evidence of both parties. Both parties usually work together to create a discovery plan, and this will outline how the documents will be exchanged. So that's the documentary part of discovery, and it will also outline when the oral discoveries will take place. And usually this plan has to be agreed upon within 60 days of the reply and defense to counterclaim, if that applies. So the next stage is the affidavit of documents. This is in relation to documentary discovery, and each party provides an affidavit of documents where they have to list all relevant documents that are in their possession. These documents have to be disclosed accurately because failing to disclose them could result in penalties or exclusion of the documents from the trial. So you'll work closely with your lawyer to make sure that all relevant documents that are in your possession have been provided. And if it's a personal injury action, then usually your lawyer will take care of getting most of the records, the medical records. they will get directly, and a lot of the records can be requested on your behalf after you sign an authorization form. The sixth step is the examination for discovery. So this is where the plaintiff, the client, has more of a role. So each party at this stage has the opportunity to question the other side under oath about the issues in the case. These examinations for discovery help to clarify the facts and narrow the issues for trial. Transcripts from these sessions can be used at trial if needed, so they can be put to the witness if their evidence is inconsistent from the examination for discovery. And there are a few other uses. I do have another video about specifically discovery, so you can have a look at that one if you want more information about this part, because it is a pretty important part of the lawsuit and one part where the client is really involved because the questions are asked of the plaintiff directly. The seventh step is answering undertakings and motions to compel. So at the examination for discovery, the parties might agree to provide additional information or documents that the other lawyer thinks is relevant that have not yet been provided. So if they agree to provide it, then it becomes an undertaking that your lawyer will work with you to provide those additional documents. And sometimes the lawyer will refuse to provide those documents, thinking that it's not relevant. So if the party fails to fulfill the undertakings, the other side can bring a motion to compel compliance. And also, if the party refuses to provide documents, a motion can be brought about the refusal, so a judge can determine if those documents do need to be provided. Step number 8 is mediation. So this can be either mandatory or it can be optional. In some jurisdictions in Ontario, like Ottawa, Toronto, Essex, the parties must attend a mandatory mediation session to try to resolve the case before proceeding further. In some other jurisdictions, this is not a mandatory step. So in the North, in Thunder Bay, it's not mandatory, but sometimes the parties will choose to go to mediation because this allows a neutral mediator to facilitate discussions, and any settlement reached is voluntary, but at this point, the parties at least are sitting down and discussing the issues. So this can really facilitate settlement. Step number 9 is the pretrial conference. So if the case doesn't settle after discoveries or at a mediation or just through talks with counsel, then it proceeds to a pretrial conference where the parties meet with a judge and they discuss the case and they try to resolve it. The judge might offer an opinion on the case, like who might be successful at trial, but it's not binding, and this judge would never be the judge who would hear the trial. So it's an opinion of a judge who is of the same level of court and who can give an opinion about the case. So it's something the parties should take seriously, but it's not the same judge who would be hearing it if it does proceed to a trial. So after the pretrial, if no settlement is reached, then the parties do go to trial. At trial, both sides present evidence and call witnesses. The judge or the jury makes a binding decision. Trials are really costly and time-consuming, so most cases do settle before this stage. Something like 95% of cases do settle before they get to trial. And I should mention that the file can settle at any point in the litigation, from even before starting the claim to any time after the discovery, or before the pretrial, after the pretrial. There are lots of opportunities to try to resolve before you get to the trial. So just another bonus tip. So this is another aspect of litigation, and it's something that your lawyer might mention, and it's a term people might not be familiar with, but motions. So throughout the litigation process, either party can bring a motion to the court, and this is a request for a judge to rule on a procedural or interim issue, such as compelling evidence, striking parts of pleadings or other documents. A motion can be brought to resolve a dispute about the case before trial. And motions can play a critical role in advancing and resolving the litigation. Understanding these 10 steps will help you to navigate the process with greater confidence. It's helpful to know what to expect at each stage of your lawsuit. And it's also good to reach out to your lawyer to discuss your lawsuit and what stage it's at so that you will have a good handle and feel confident throughout your case.